You are welcome to Employment Law class. Today you will look at Section 1 of Unit 4, which is on meaning and nature of contracts. Session objectives. By the end of this session, you should be able to explain what is meant by law of contract, state the elements of contract, identify the classifications of contracts. A contract is an agreement enforceable or recognized by law whose essential feature is a promise by one party to another to or forbear from doing certain specified acts. So basically, when you talk about a contract, you are saying that, look, there has been an agreement between the parties. That agreement is enforceable or recognized by law, meaning that the contract should be, the agreement should be lawful. The definition excludes unlawful contract because unlawful contract is not recognized by law and whose essential feature is promised by one party. So promise here, you are talking about the consideration. Promise here, you are talking about consideration, and consideration may take the form of doing something or forbear something. So this element is the issue about consideration. So you agree with one party to do certain acts in exchange of promise in return, and that agreement will be enforceable by the law court. The agreement should not be tainted with illegality. So when this essential element comes together, then we say that there is an existence of contract. Very soon, look at the elements that should be present in an agreement or in a contract for there be a valid contract. What should you do before making a contract? So if you want to make a contract, make sure you understand what you have promised and what you are promising. Make sure you understand what you are promising. You also make sure that the contract will protect your interests. So what you are entering, make sure that it will protect your interests. Only make promise which you can keep. So if you are making promise, don't go and make unnecessary promise that you cannot keep or discharge your obligation. Write your contract down and make sure that everyone involved has signed. So the contract here is not always the case, but in written contract, all those who are supposed to sign must sign. But if it's not written contract, the issue of signature will not arise. Possibly get a legal advice. Some people, they will not seek legal advice. It's only when they are falling in trouble before they will seek legal advice. Seek legal advice before you enter into a binding contract. Classification of contracts. You have simple contract, the ordinary contract. That's where a contract is between two persons and may require consideration. That's oral or written. So simple contract may require consideration. Consideration is the price element in a contract. What you have paid. It is not always money, but it can take different form. Specialty contract or contract under seal or deed. Here there's a written instrument signed, sealed, and delivered. In specialty contract, consideration is not required. So when you come to specialty contract or contract under seal, there is no issue of consideration. So specialty contract is the one which does not require consideration. As you indicated, you can have verbal or written contract, any of them that you choose. We also have unilateral contract and bilateral contract. Unilateral contract is contract made by one person to the whole world, in which acceptance requires performance of a certain act. So for unilateral contract, the offeree. So in contrast, we have there will be an issue of offer where we have offeror and offeree. In unilateral contract, the offeror does not expect the offeree to communicate his acceptance. However, the offeree is required to perform the act in a specified manner. So a typical example is Kale versus Carbolic Smoke Ball. Here the company advertised a product and said anyone who will use the product in a specific manner and continue to suffer from influenza, they have deposited certain amount in the bank which they wish to take care of that person. Now the plaintiff bought the product using the manner in which it was prescribed, and he still contracted the influenza. The court held the company liable for their work. So the mutual contract is made by only one person and require performance as a form of acceptance. No communication of acceptance is needed. Bilateral contract is normally between two parties or their agent on specific terms, or specify either specific or particular terms. Now, elements of a valid contract. In all contracts, there should be an element of offer and acceptance. The offer and acceptance gives you what you call an agreement. When there's offer, when there's acceptance, there's an agreement. Then the issue of capacity, we look at them into details in our subsequent discussion. Whether or not you have capacity, and at what age would we say a person has a capacity. Under common law, the age of 21 was said to be the contracting age. In Ghana, we have not passed any contractual age, so we go by the common law position, which requires that a person with age 21 and above has the capacity to enter into a contract. We don't have intention to create a legal relation. Then legality, we have certainty of terms. The certainty is not to say it's not specifically an element, but it's a minor, let me say it's a minor element. There should be a term, but the term should be specific, should be clear and certain. So, but the key element should be that the contract is legal. So the legality of the contract and consideration. So basically, the major valid elements of contract include agreement, which often acceptance, capacity, intention to create legal relation, consideration, and legality. This would be a minor element. A minor element. Now you have void contract. Void contract means that contract doesn't exist. An example of void contract include contracts involving illegal subject matter. A contract to commit a crime is a void contract and cannot be enforced at a real court. Enforcement to constitute prostitution, gambling, they are all illegal contracts and it is void. Void means it does not exist and it will not have any effect. Hence, the court will not enforce it. Contract entered by someone not mentally competent. So if you enter into a contract with a person who is mentally incompetent, the contract is void. However, in certain circumstances, the contract will be voidable, especially where the person is on and off. Sometimes the person is in his right senses, sometimes the person is not. So in that side, when you enter into a contract with a person of unsound mind, that contract is voidable. It is not necessarily void. It is valid unless someone takes steps to set that contract aside. So this one will not be precisely be considered void, but it will best fit in voidable contracts. Voidable contracts. This will fit best under voidable contract. So let's mark this one out. Contract that require performing something impossible or depend on an impossible event. That one too is invalid. Contract that against public policy because they are too unfair. If the contract is against public policy, it will be deemed to be void. Public policy is very difficult to define. However, people are tending to explain that anything that goes against the conscience of the general society is against public policy. So this one, and that's void. We have voidable contract. So contract entered into when one party was a minor, you enter into a contract with a minor, that contract will be voidable. Voidable means that it is valid until someone takes steps to set it aside. Also, where one party is tricked or forced to enter into that contract, that's here you're talking about misrepresentation or duress. That contract too is voidable. Contract entered into when one party was incapacitated, like intoxicated person, insane person. That contract is voidable. Means that it exists first unless one person takes a step to set it aside. In this session, we have attempted to explain what is meant by a contract, also explain when a contract is used and what should be done before a contract is formed. We also try to identify the classification of contracts. Thank you and have a nice day.